Good morning, listeners, and welcome to yet another podcast series brought to you by Legis Indica. Today we're discussing the Supreme Court of India's reportable judgment in GAYATRI Balasamy versus ISG NOVASOFT Technologies Limited. Our deep dive today tackles a pretty fundamental question in Indian law. When an arbitrator makes a ruling, can a court actually just fix a part of it, maybe modify it, or does it have to throw the whole thing out? And this isn't just any ruling, it's from a constitution bench. That means 5 or more judges involved, signals serious legal weight, reserved for the really big constitutional questions.
Absolutely. And for years, this exact question it's really split judicial opinion, hasn't it? You had earlier judgments like McDermott International and Project Director NHAI versus M. Hakim. They leaned heavily towards very limited intervention, basically no modification allowed.
Right. Just set it aside or leave it alone.
Pretty much. But then you started seeing other cases, like Vedanta Limited, for instance. And they began suggesting, well, maybe modification is possible, but only if parts of the award were severable. You know, if you could cleanly separate the good from the bad.
Ah, okay. So a crack in the door, maybe?
Sort of.
Yeah.
And this division, this lack of clarity, is what ultimately pushed the Chief Justice to say, okay, we need a constitution bench to settle this.
Makes sense. So to really get this, we should probably unpack the specific case that triggered this ruling, right? The GAYATRI Balasamy case itself?
Yes, exactly. It started with an employee, GAYATRI Balasamy. She filed a criminal complaint against some senior officers in her company.
Okay.
After various legal twists and turns, the whole thing ended up in arbitration. And the arbitrator awarded her quite a substantial sum. 2 crore rupees.
2 crores. But she wasn't satisfied.
No, she wasn't. She actually went to court seeking to set aside the award she'd received. And this is where it perfectly shows the problem we're talking about. The Madras High Court didn't just set it aside, they modified it. They added another 1.6 crores.
Wow. Okay, so they actively changed the amount.
They did, but then it went on appeal to a division bench. And what did they do? They reduced that extra amount down to just 50,000 rupees.
50,000 from 1.64. That's quite a roller coaster.
Exactly. A roller coaster of modifications. It just threw the court question into sharp relief. Do courts even have this power to tinker with awards?
And that brings us to the Supreme Court's big decision. What do they say?
Well, here's the headline ruling. By a 4-to-1 majority, with Chief Justice Khanna writing for the majority, they ruled that, yes, courts do possess a power to modify arbitral awards under Sections 34 and 37 of the Arbitration Act. But, and this is crucial, it's a limited power.
Limited?
Okay.
How limited? And Sections 34 and 37, those are the main ways to challenge an award, right?
Yeah. Correct. Those are the key provisions. And the majority didn't stop there. They also specifically confirmed the power to modify post-award interest if the circumstances warranted it. Another layer of judicial ability to step in.
Okay, so what was their thinking behind this? Why allow modification at all after years of leaning the other way?
The core reasoning, it's quite interesting. They use this principle. If a court has the greater power to completely set aside an award,
Throw the whole thing out.
then logically it must also have the lesser power to just partially set it aside or to modify it, especially, and again, this is key, if the invalid parts are clearly severable.
Severable, meaning you can cut out the bad bit without destroying the rest of the decision. They used a Latin phrase for this, didn't they?
They did. Omne magis continent in se minus. The greater contains the lesser. It's that idea.
And practically speaking, what were the concerns?
Well, they worried about absurd outcomes if modification wasn't allowed. Think about it. Forcing parties back into a whole new arbitration just to fix, say, a calculation error. That means more hardship, huge costs, massive delays, when a court could potentially fix it right there.
That makes sense, especially for simple mistakes, right? Like typos or math errors.
Exactly. The court clarified that those kinds of errors, computational, clerical, typographical, can be modified directly by the court hearing a Section 34 application. Much more efficient.
Did they address the international angle, like how this fits with enforcing foreign awards?
Yes, they did. The majority was clear that this limited domestic power to modify wouldn't interfere with enforcing foreign awards under the New York Convention. They stressed that domestic law governs the setting aside procedure.
And what about the Supreme Court's own special powers? Article 142.
Right. Article 142, the power to do complete justice, the majority acknowledged this can be used. Primarily to end long drawn-out litigation, save time and money, but crucially, not as an excuse to rewrite the award based on merits. It's more about finality and efficiency.
Okay, so a limited power to modify focused on severability and efficiency. But it wasn't unanimous, was it? There was a dissent.
That's right. Justice Viswanathan dissented, and his view was fundamentally different. He argued that modification is not simply a lesser power contained within setting aside, it's a distinct power.
And the Act doesn't explicitly grant it.
Precisely. He emphasized that the 1996 Arbitration Act was designed for minimal judicial intervention. The Act clearly says courts can set aside an award on specific grounds. It doesn't mention modification. So reading that power into the Act, in his view, was basically judicial overreach, going against what the legislature intended.
And what about Article 142 in his view?
He felt Article 142 couldn't be used to sort of bypass the substantive law. You can't use it to achieve indirectly, like modifying an award, what the law doesn't directly permit. It shouldn't supplant the specific provisions of the Arbitration Act.
So a really clear disagreement there on the scope of judicial power versus legislative intent.
A fundamental difference in interpretation, yes.
So wrapping this up, what does this decision mean for, well, for everyone involved in arbitration in India?
I think it signals a significant evolution. It's the court trying to find a balance, balancing the need for arbitration to be efficient and final with the court's role in making sure justice is ultimately done. It's a fine line.
And this idea of severability seems really central now.
Absolutely. The distinction between severing invalid parts versus modifying the substance and clarifying how different types of errors are handled, that brings more clarity. It could potentially streamline things, allowing courts to fix specific, identifiable problems without automatically triggering a whole new arbitration process.
Which could save time and money in some cases.
Potentially, yes.
Okay, so here's a thought for you, our listeners, to ponder on. Given this nuanced decision allowing modification, but only in limited severable circumstances, how might this change things on the ground? How might businesses or individuals approach drafting their arbitration clauses now? Or even just manage their expectations about how final an arbitral award really is in India? Something to think about. Thanks for listening. Don't forget to like, subscribe, and stay tuned for more updates on key Indian Supreme Court's decisions.